You are listening to MyHRBuzz, brought to you by MyHR Concierge. Hosted by Chris Cooley, we'll bring you various topics and guests to shed light on the often confusing world of HR and also employee screening. We'll be putting the human in human resources.
I want to thank you for joining us today on MyHRBuzz podcast. I do want to remind you that we can be found at all of your favorite podcast locations. And when you do find us, make sure to hit that subscribe button. And if you like it, tell a friend. Well, today I've got Bill Gault and Wendy Shelton with us here from Nippus, Healy and Gault. And if you're a friend of the podcast, you've seen them before. They've done several podcasts with us, and they always do a great job. And I appreciate you guys being here today.
Thank you, Chris.
Thank you.
Yeah. Well, and what we wanted to talk about today is the June 28th of 2024, the Supreme Court overruled the Chevron Doctrine. And that's something that, quite honestly, probably most people don't really understand how that's going to affect employers. I didn't have great knowledge of the Chevron Doctrine, which is why Bill and Wendy are here. And so what I wanted to do is let's talk about that and let you know how that's going to affect your business and how this rulemaking changes are going to change. And so, Wendy and Bill, tell us, what is the Chevron Doctrine? What was that?
Bill, do you want me to take that one?
Sure.
The Chevron Doctrine came from the 1984 Supreme Court case Chevron USA Inc. versus Natural Resources. In that case, by just 6 justices, the court veered away from the traditional approach of the courts interpreting legislation and came up with a 2-step process and decided that if Congress had not directly spoken to the issue, they would go to step 2. And if a statute was silent or ambiguous with respect to an issue, the reviewing court would defer to the agency's construction as long as it was a reasonable or permissible construction of the statute. So instead of the courts deciding every issue of statutory interpretation involving federal agencies and their rules and regulations that the agencies themselves came up with under their governing statutes, the court in Chevron decided that the agencies could, for the most part, do it, and the court would generally defer. At first, the Chevron decision, though it is a big shift, wasn't well understood or followed, but as the 40 years went on, it started to be used, and in particular with respect to DOL rules and regulations. For our listeners, they may be familiar with the DOL getting to use its interpretation of statutes and enforce that. But towards the end of the last 40-year reign of Chevron deference, it had been whittled away at, and the Supreme Court itself had not deferred to an agency's interpretation since 2016, although lower courts still were using it frequently.
Okay, so essentially, it sounds like it had been watered down anyway, to some extent.
It had.
It had, okay. Because it's funny, as doing research as this came out, depending on which article you read, this is either the greatest thing that has ever happened to democracy or the absolute worst thing that has ever happened to democracy. Just kind of depends on where you are. It's probably somewhere in the middle. But it's funny how that has been interpreted, if you will.
Yeah, from a practical standpoint, and the Chevron Doctrine is also known as Chevron deference because of the deference to the various federal agencies. But from a practical standpoint, rather than federal agencies going into federal courts with this benefit of deference, then now they're going into federal court on a equal playing field, if you will, because the courts are no longer going to afford them deference. they can consider what the agency ruling was, but it's not controlling any longer. The courts are Article 3 courts, and they are required to independently interpret the law, which had, under the Chevron deference or Chevron doctrine, had been deferred to the federal agencies.
And I guess the thought of that originally was, from what I've read, is the agencies are the ones that have the technical knowledge to theoretically, if something is ambiguous, they should have the knowledge to be able to say, this is what makes sense, because that's their field, right? And then rather than a judge, but now I guess the thought is that they should not have that deference, because now you're moving something that should be taken by the courts. They kind of move that over to this agency, which could or could not take advantage of that.
Right.
That's
it's
true.
A separation of powers issue between the judicial and executive branches, with the agencies being part of the executive branch.
And I think that the other thing is that these federal agencies are so political. I mean, depending on who's in office and who appoints them, those policies are politically motivated. Whereas when you get into a federal court, you should have a even playing field or equal playing field, and the judge should be an independent decision maker.
And I think that's a good point, because not really, and because I think that happens on the left and the right. Right. To your point, it's just whoever they were appointed by, typically that's the way it's going to lean.
Exactly. Prime example of that, NLRB, predominantly Democratic appointed members. The Federal Trade Commission, as we saw in the last podcast, predominantly Democratic appointees. So how are they going to rule? They're going to rule in favor of a more liberal interpretation of these regulations. And now they're attempting to, this ruling or the opinion by Judge Roberts is seeking to restore some credibility to the decision-making process, I believe.
Yeah.
Right. The meaning of some of these rules had changed multiple times from what I've been reading, depending on who was in office. Right.
Yeah. And I think both parties take advantage of that for sure. Definitely. And so, yeah. And one thing, talk a little bit about, as we're going through this and how these agencies have used this doctrine. So for instance, one of the big things today is the overtime rule. Right, because that it just went into effect. We've got another raise in the minimum salary threshold going in January. Now, as I understand it, as written in the FLSA, there is no minimum salary. That was written as part of an agency put that in there. So I guess that is an example of how these agencies have taken that ambiguity and kind of shifted and formed these rulings in the way they would like them to see them, rather than from any kind of congressional, what Congress has intended.
I agree. And I think the non-compete ban is another prime example of that. There's no authority to ban non-competes nationwide. That's something that the FTC voted to do. I believe, Wendy, what was that vote? 3-2, about 3-2 margin. I mean, it was a narrow margin, and that's strictly an agency decision. That wasn't a court decision. That's why there's the court cases out there over that issue.
Yeah, and as I understand it, the ruling does not affect any. I mean, it doesn't affect any prior rulings, right? So if you had a case a year ago, it still stands.
Right.
Where this primarily affects is going forward.
That's true. But on Monday, the Supreme Court also decided the corner post case and held that the statute of limitations, the 6-year statute of limitations, doesn't expire. Basically, it held that if a business is being injured by a rule, the business can challenge the rule. So that ruling, coupled with the decision in Loper Bright, may open the door to many more challenges than just the Loper Bright decision would. Because if you are being harmed by a rule, you can challenge it now. But right, the past decisions are in place, but you can bring a new challenge.
Okay. So I guess prior to that, if there was a rule that harmed me, I had to do something in 6 years.
That's
Is that
right.
Okay. I wasn't familiar with that statute. So now they basically opened that up and said there is no statute of limitations.
And well, as I appreciate it, if the harm occurs outside that 6-year window, and say the harm occurs in year 10, then that is still a viable cause of action. Whereas if it had not, and that was what I think, was it Sotomayor, Wendy, that said, well, now you've got open-ended statute of limitations. You can sue for things that over regulations that were implemented 10, 20, 30 years ago, if you're not harmed until 10, 20, 30 years later.
That was the dissent, argued that really basically what Chris said throughout the statute of limitations completely, but you do still have to suffer harm.
Yep.
Okay. So you could conceivably, to your point, I mean, it's wide open at this point. They could go back as far as needed, to your point, as long as they have harm. But this isn't going to open up. If I had a case a year ago that I lost, I guess I could conceivably bring another case, but it would have to be on a separate issue or a separate instance. Is that kind of the way that would work?
I believe that is the way it would work.
Yes,
but it would be essentially, it would be essentially a new cause of action.
Gotcha.
The old cause of action has been disposed of.
Okay. But now, also, what happens is it can be used if there are ongoing cases. So, for instance, I know there's cases against the overtime ruling, the non-compete, and others. It can be used in that because those aren't finalized. So now they don't have to provide that deference to the agency.
That's the way I interpret it. You got the joint employer rule. You've got independent contractor rule that's out there. I think those are probably the major. You've got the overtime rule, the joint employer rule, the independent contractor rule, and the non-compete ban. Those are the hot employment issues that could be affected by the overturning of the Chevron doctrine.
So how do you guys see this affecting kind of the landscape of these agencies and how they're going to make their regulations now? Is it going to be, do you see it as a lot less onerous? And what I mean by that is maybe they're not as aggressive. I mean, how do you think this is going to play out?
I think it's going to force these agencies to tighten up their drafting and the language of these regulations so that they aren't vague, that they aren't ambiguous, and that there would not be a need for the court to interpret them.
I mean, do think that's true.
Yeah. In the past, it was a pretty easy task. You know, agency says, whether it's the DOL, NLRB, EPA, whoever says, well, we're going to promulgate all these regulations, and hey, they're a little vague, whatever, is our interpretation will be given deference and will control.
Yeah.
I
So
think they will have to be more careful, and employers will need to consider whether existing rules are worth challenging.
So there, one thing I read is that this is really going to breed a lot more challenges, to your point, because what's going to happen is as these regulations are laid out, employers will have, I guess, a better chance, to your point, of winning the case, assuming it's valid, right? And so with that, how does that affect employers geographically? So are these cases, so for instance, if I have a case on a topic, we'll say overtime. We're going to say we're going against this overtime, the minimum salary. Is this an issue where if I go to the Ninth Court and I lose because they rule in favor of the agency, and then another individual or another employer has a case and they're in the Fifth Circuit Court, and they win, how does all that correlate? So can we have different overtime rules kind of based on rulings in the different circuits? Is there a way that that's going to be more nationalized if we do have these court cases? How do you foresee that working?
I think, Chris and Wendy, you certainly may be well versed or better versed than me on this, but splits in circuit courts of appeals happen all the time.
Mm-hmm.
And when there's a split in the circuit courts of appeal, generally that issue is going to work its way to the Supreme Court to resolve that split in the circuits. So yes, you could have a and I mean there are like hundreds of examples out there right now where the Fifth Circuit, which is largely considered one of the more conservative circuits, has a lot different laws that apply within the boundaries of the Fifth Circuit than some of the other circuits. For example, DC Circuit or First Circuit or whoever.
Interestingly, I believe I read that 6 of 10 Fifth Circuit decisions that went before the Supreme Court this term were overturned.
Really? Now say that one more time.
6 of 10 is what I read of the Fifth Circuit decisions that went before the U.S. Supreme Court this term were overturned.
Wow. Okay. I didn't realize that.
That's what one article said. I haven't checked those specific cases, but
one was social media.
Back up.
Yeah, one was a social media case
Yes.
that was overturned by the Fifth Circuit. I mean, by the Supreme Court, Fifth Circuit ruling.
Okay, I didn't realize that. So what this could lead to, I guess, unless there's some kind of national stay from an employer perspective, specifically now, because everybody has a lot of companies are in multiple states, right? Because of remote employees and those kind of things. So I guess conceivably employers, it could lead to more where they are having to manage multiple regulations or differing regulations between these geographical circuits until it does make it to the U.S. Supreme Court. Is that true?
I think that's accurate.
It's a possibility, but again, I don't know that the agencies will be pushing their interpretation as hard as they have been without the backing of the Chevron deference. So I'm not sure how much it will happen as a practical matter, but it definitely could.
Okay. And that makes sense.
One thought on that. One reason that I saw in some of the information I was reading, getting ready for the podcast, was that the Chevron deference or the Chevron doctrine had not been really applied that that much recently. And Wendy, I think, said the last time it was applied was 2016. And one of those reasons is that there's a doctrine out there called the Major Questions Doctrine. And that doctrine says, and it's been out there for years. It says that that federal agencies can't regulate major economic can't regulate things of major economic or political significance if Congress hasn't given them explicit authority to do so. So that's one reason that I think you've seen a backing off of the reliance on the Chevron deference standard, with the last case being in 2016.
Okay. And to your point, but the lower courts are still using it, I guess. And then I guess what happens is they use it at the lower courts, and then that filters up to the Supreme Court, where I guess they have not been providing that deference as much.
That's right.
Is that right? Okay. No, that's good. Well, what else? I mean, with this, is there anything else that you guys can think of how this is going to affect employers? It seems like just kind of at a really high level, essentially what's going to happen is more than likely you'll have a little less aggressive agencies. And then you'll probably, if you do have a perceived harm, we'll probably see more cases fighting those agency regulations when it is deemed or perceived that they've overstepped their boundaries, because they probably have a little better case to do that now, to win those if there has been that harm.
I would think that would be the case in our area. Just in the last few weeks, I've had the EEOC be a little more aggressive and tell me they were asking me for things based on their practice. I think that sort of thing may be chilled for now until we see what happens next with all of this.
No, that's good. Well, no, I think this has been very informative because, as I said, how that worked, I was not that aware of it. And I was also not aware of what that effect was to employers as these agencies use that deference. And with that gone, specifically, it sounds like maybe not at the Supreme level, but as that has occurred at the lower level, employers may have more of a ability to fight some of those perceived harms when those rulings come down, regulations come down. So, no, I appreciate both of you guys jumping on. Again, y'all always do a great job, and I appreciate it. And so tell us how, if someone does have questions or needs, or how can they reach you guys? What's the best way to contact you?
Sure. Wendy, I'll give my office number. Bill Gault at Nippus Healy and Gault, PLLC. Office phone is area code 601-952-2592, extension 114.
Perfect. Well, great. Well, no, again, I really appreciate both of you joining us today.
By all means, we appreciate being here. Thank you.
Thank you for listening to the MyHRBuzz podcast presented by MyHR Concierge. For more information on this topic and many others, please visit our blog at www.myhrbuzz.com. It's a free resource and has a lot of great information on HR and employee screening related topics. If you like the podcast, please do 3 things for us. 1, leave a review. 2, subscribe to the podcast. And 3, tell a friend. Our podcasts are available on iTunes, Spotify, and many other places where you get your favorite podcasts. If you'd like to provide ideas or feedback on future shows, send us an email at podcast@myhrbuzz.com, or you can reach us at 855-538-6947, extension 108. This is Chris Cooley with MyHR Concierge. Thank you for joining us, and we look forward to sharing more topics with you in the future.